Please note that this video provides general legal education and not tailored legal advice. If you need tailored legal advice, please apply to Q Legal's free legal advice clinic.
Welcome to this QLegal video on collecting and processing health data. After watching this video, you will understand what counts as health data, the extra steps required when collecting and processing health data under UK data protection law, and the common pitfalls for staying compliant. When we think about data, we often imagine names, emails, or contact details, but some information is far more sensitive. For example, health data. Health data includes any information about a person's physical or mental health, whether it's a diagnosis, fitness level, mood tracking, or even sleep patterns. Under the UK GDPR, health data is considered special category data, meaning it is subject to more stringent requirements and needs stronger protection because misuse can lead to real harm to people. Importantly, the UK Information Commissioner's Office, or ICO, explains that even inferences can count as special category data. For example, if someone frequently buys books about pregnancy, their behavior could lead to an inference that they are pregnant. That inference is considered sensitive health data and is special category data with stronger protection under the UK GDPR, regardless of whether the inference is accurate or not. Let's use the example of a fictional startup named Coffee Clothes. Coffee Clothes created a well-being app that helps users track their mood and well-being. Every time a user logs their mood or well-being information, that's health data being processed. Before launching, Coffee Clothes considers whether a data protection impact assessment is needed under the UK GDPR. A DPIA is mandatory before carrying out processing that is generally likely to be high risk, and the ICO requires specifically that a DPIA is completed by organizations processing health data or profiling users on a large scale. Even when a DPIA is not required, it can help identify risk early and ensure that appropriate safeguards are in place prior to data processing activities. Also, prior to processing, Coffee Clothes should determine what lawful basis it can rely on for processing personal data. In this case, Coffee Clothes determines that due to the implication of health data, mood and well-being data, it should rely on the lawful basis of consent. Under the UK GDPR, consent must be freely given, specific, informed, unambiguous, and easy to withdraw. Next, because health data is a special category data under the UK GDPR, Coffee Clothes must also identify a condition under the UK GDPR to justify the processing. As consent is the lawful basis, the most appropriate condition will be explicit consent. Unlike standard consent, explicit consent requires a clear, specific, positive action such as a written statement or a tick box accompanied by an express confirmation. When designing the app, Coffee Clothes therefore implements a consent pop-up. Users need to actively select an optional checkbox to indicate their consent preferences before they will be able to access the app. This checkbox can read out, to help track your mood and well-being, we need your permission to collect and use well-being information. Providing this information is optional. If you prefer not to, you can still use other features of the app, such as our guidance on mood and well-being. You can withdraw your consent at any time through your app settings. If a user withdraws consent, the company must stop collecting and using that user's health data from that point forward. However, any processing carried out before they withdraw their consent is still lawful. Now, to secure the data and to implement appropriate technical and organizational measures required by law, Coffee Clothes uses pseudonymization, encryption, and multi-factor authentication. Also, to comply with the UK GDPR principle of data minimization, Coffee Clothes ensures it only collects the data that is strictly needed for processing. Coffee Clothes will also share health data where it is necessary to provide the service and only after users have been clearly informed of this processing. These steps aren't just good practice, they build user trust and are required under law. Common pitfalls and lessons for startups. When developing the app and preparing the DPIA, Coffee Clothes faced and addressed a few common data protection pitfalls. Coffee Clothes initially wanted to collect more data than necessary, such as pre existing medical conditions and so on, but realized this violated the UK GDPR principle of data minimization. Therefore, it ultimately decided to limit the data the users could provide to mood and well being data. Another challenge was transparency. While Coffee Clothes had prepared a privacy notice, it was long and hard to find. Therefore, Coffee Clothes supplemented its privacy notice with short, user friendly pop ups in the app that referred individuals to more detailed privacy notice if they wanted more information. Another mistake, weak internal controls. During testing, every developer could access user data. After reviewing the ICO's guidance on security, Coffee Clothes encrypted user data and introduced multi factor authentication, ensuring only authorized staff could view sensitive health data. By addressing these issues early, Coffee Clothes turned compliance into competitive advantage. Thank you for watching this QLegal video on collecting and processing health data. Now that you watched this video, you should understand what counts as health data, the steps you need to take to comply with the law, and common pitfalls and tips for staying compliant.
For free legal advice tailored to your business, please go to the QLegal website and apply to the QLegal Legal Advice Clinic. For additional videos and other helpful resources, please go to the QLegal Resource Hub.